Welcome to Notable Approvals. I'm attorney Amanda Shaffer. Today we have another marathon case to talk about. Before I get to it, just a reminder, make sure to like us and follow us on Facebook and Instagram and Twitter and YouTube so you don't miss any more of our future lives. So the case today that we're talking about is about a child support violation case. Now, this client is actually a permanent resident of the United States and a citizen and resident of Canada. So she lives up, I think, in Montreal. She had lived in New York prior to moving back up to Canada. Now she filed for custody in Canada. She received custody, full custody of the two kids. And then she filed for child support in New York. And I wasn't her attorney back then, but my assumption is that since New York does income withholding orders, it might be hard for Canada to do an income withholding order in the States. And what that is if you get a paycheck, you have a certain amount of wages garnished every paycheck for the child support or payments by the child support agency, and then they send it to the person who's supposed to receive the money. So there's no direct transfers of money between mom and dad. It goes, basically, it gets taken out of his check and then sent to her in the form of a check. So she filed in New York, where dad lived, and where they had lived prior to her leaving. And in 2017, it was when we first got hired. The case had already started at that point. And at the end of 2017, we had a trial. And we had a trial on two things. One was the final child support order, and two was the motion to terminate child support filed by dad, who claimed that he hasn't seen his kids, so he shouldn't have to pay child support. That easily got dismissed. Just for the record, child support payment and visitation are two completely different things. It's not like you gain your right to see your children by paying. It's not like if you don't pay, you don't get to see your kids. Certain things can be taken into consideration for, like, custody. If you can't afford to pay child support, how can you afford to have the kid in your custody? But for the most part, you have a right to see your children no matter what, and that's independent of making child support payments. So at this final child support hearing, we also talked about dad's job. Now, dad had worked at Popeyes for like 20 years. And by the time the trial commenced, he allegedly had lost his job through no fault of his own, because the store closed and had already been closed, I think, a few months. But he had no evidence that he had been searching for jobs. So the judge based the final order of support on his income from his previous year taxes that he had filed, and that's common. The last year that you file taxes, what your income before the proceeding commences, what your income was on there is what the judge is going to base the child support award on, unless there's a reason to modify it, such as if he had lost his job through no fault of his own and made every effort to secure a new job and failed. But that wasn't the case here. So October 2017, we have a final order of support. Then dad's unemployment compensation ran out in 2018. So the only reason he was paying it at first was because the wages were still being garnished from his unemployment checks. When that ran out, he actually filed another motion to terminate for the same reason, that he doesn't get to see his kids. And also, for the record, this wasn't my client. This dad never filed for visitation, which, if you're going to say, at the very least, you have to try to see your kids if you're going to say that they're being withheld. That's a whole separate issue. Anyways, we were able to get that dismissed, but the payments just stopped completely for a while. And by the time we decided to file the violation petition, my client was owed over $13,000. So, we went back to court. We filed a violation petition. We served it on him, and he didn't appear. And we got a default judgment against him for all the arrears for attorney's fees, because that's required under statute. If you default, then it's automatically presumed a willful failure to pay. And if you willfully fail to pay, you're responsible automatically for the other side's attorney's fees. And I remember this very vividly because I had to wait all day court to get a warrant of arrest. It had to be served on him, which it was. And then after that happened, I left for vacation. And I got a frantic call from Aaron that, hey, did you know that the case was reopened, the child support case? I was like, what do you mean? How is it reopened? So apparently when he got the judgment, the warrant of arrest, he went to the court, claimed he never got served, and what the court should have done was notified us, and that either myself or Aaron could have appeared and argued. And once again, we had to prove to the judge at the default hearing that we served him, but we would have proved it again. Instead, they just went ahead and reopened the case and vacated the arrest warrant and the money judgment, which was very frustrating. So that meant that we then had to have a trial on the issue. So whenever you're doing a willfulness trial, there are two parts. You have to first, the person who's claiming the alleged violation has to prove that there was a failure to pay. That's usually the easy part, especially if you do have income withholding orders, because the child support office gives you a breakdown of all the payments received, all the payments owed, and you get that every time you go into a child support hearing when there's an IWO. And basically that becomes evidence, and my client testifies she didn't receive money from this date, and even the dad admitted he didn't pay for a period of time. So that was easy. Once you establish the failure to pay, you then have to, then the burden, we had to prove failure to pay. Now it changes. The burden now goes to dad, or the person who didn't pay, to prove that, yeah, I didn't pay, but it wasn't a willful failure to not pay. I was unable to pay. And there are different ways of showing this. It's not easy, but one of the ways is what he was kind of arguing in the first trial. I lost my job. I haven't been able to find a new job. Interesting side note that it just so happened at the time of, by the time we got back to court where they reopened the case, the dad had all of a sudden had his job back and started making payments again. But that didn't change the fact that he wasted all this time not paying, still owed a lot of money, still forced my client to spend money on attorney's fees, and put her in a position where she went months worrying if she was going to be able to support her children. So ultimately, we won. Oh, that's a vet calling me. Ultimately, we won on the issue of willfulness because we showed that, look, he claims that he was searching for a job all this time, but he didn't present a job diary, which is basically, you know, a list of all the places you've applied, what happened, the dates. He didn't, all he said was, I walked around, like, I think 125th Street and went into different restaurants and asked them if they needed anyone to work there. And he couldn't give us dates. He couldn't tell us how many restaurants. He couldn't tell us the name of the restaurants. He did admit to being offered a few jobs, but they paid less than his old job, so he turned it down. So he could have made partial payments at least, but he didn't. And I mean, he claimed he had no other assets. He didn't live a very fancy lifestyle. He wasn't putting money towards other things. We did have reason to believe he had gone to Africa a bunch of times where he's originally from, but we didn't even have to get into that because, you know, those plane tickets are expensive. Bottom line is, you can't just walk into court and say, I lost my job. I tried really hard, but I couldn't find another one, and now I can't pay child support. It just doesn't work that way. You need proof, and you have to look for jobs within your experience. So this client, he had some type of finance degree from Mali, but he didn't speak great English, even though he's been in the U.S. for like 20 years. He was a citizen, but he's been a chef at Popeyes for basically his whole working career. And so the argument that they made was he can only get chef jobs, and that's fine, except that he didn't even prove that he tried to get chef jobs. So we won that, and then he was also ordered to pay, at this point, what was substantial attorney fees, more than the arrears. And that is because all the stuff that happened with the default, and then these cases are they have no time to hear cases in a block. So we had an hour here, an hour there. I think it was at least 6 days of trial spread out over months, which made it even harder if you've ever done in a direct or a cross-examination, and you've been interrupted by a substantial period of time, it makes your job much harder. I wanted to also say, by the time they entered the second finding of willfulness, he had actually paid the arrears down a lot. He had been making the money had been withdrawn, but he had been making payments on top of it in order to decrease the arrears in hopes that it would show his failure to pay was not willful. But it doesn't change the fact that it had been in the past. He's liable for those arrears, whether there's a willful findingness or not. So that didn't cut it with the judge either. He also tried filing again. I think I said the motion to terminate for the same reason, that he didn't see his kids, and that didn't come back. So after we won, one other thing about what the judge ordered with the violation. Initially, I mentioned there was an arrest warrant. If you owe over a certain amount of child support, you can be jailed until you pay what's called a purge amount. So let's say you owe $13,000, the judge might say, pay $5,000 now or you're going to jail. And you wait there until you get $5,000 magically. That's what the law says. But this time around, the judge did not order him to be in prison because the judge said, look, he has made arrears payments back, paid back some of the arrears. He has a job now. He's paying now. And we didn't have any proof of any assets he owned that he could have easily converted to cash, or any cash he was hoarding, or any imputed income we can have to show that he could pay like a $5,000 amount right now. So because of that, it wouldn't be fair to stick someone in jail who isn't going to be able to get out. That was fine. We didn't need him to go to jail. In fact, we didn't want him to lose his job if he were to go to jail because of that. So after we won, what happens is, in family court, there's something called objections. And if you go to a referee, or a support magistrate, I think we have a support magistrate, not a referee. It's almost like an appeal. It's basically an appeal, but it stays in the same level of court. It's just that instead of a support magistrate reviewing it, or referee, a full judge reviews it. And every time there's an objection or an appeal, I have to respond. If my client hires me to respond to it, which she did, I have to respond. And even though the objection, in my opinion, was frivolous because there was zero proof this guy tried to get a job and didn't even try once proceedings started. Well, not once proceedings started. Like I said, he didn't have the job at the old hearing, at the first initial child support hearing, and he had an attorney. And his attorney should have told him to, make this job diary, especially if you want to do a downward modification in the future. Didn't do any of those things. So we responded to the objection. The judge agreed with us that the record supported the judge's determination that there was a willful violation, and again ordered the attorney's fees. And we thought that was it. Then he does an appeal. Now, I should also mention that this attorney did have a retained counsel for the final child support hearing. But when he came back after that warrant of arrest, he told the judge he was indigent. He didn't have it, he made below the poverty guidelines. He needed a lawyer, so they appointed it. So the entire willfulness trial, the entire objection that we had to do, in response to the appeal, he wasn't paying any attorneys to do it. The state was paying the attorneys to do it. But my client still had to pay us because otherwise she wouldn't have any representation. So it can get really expensive for one of the parties in that case. The appeal actually was a different lawyer than the first lawyer, but it was the same argument, again, frivolous argument, that basically tried to say that he had plenty of evidence of his willfulness because he said he tried. It wasn't even anything really to talk about, but essentially I still had to reply because, you never know. And they cited all this case law and the facts didn't match the facts in our case. They didn't distinguish the cases. It was very poorly done. But unfortunately, I still had to respond and do my best, which I did. I went through every case. I said, this is what the case actually said. These are how the facts are different than the facts in our case, and why this warrants a different conclusion. So finally, I'm happy to say that we got the appeal back, and the appellate court agreed with us, agreed with the court below, that there was a willful failure to pay child support, and ordered and not reinstated, affirmed the money judgment. So can it be appealed again? Technically, there's another level of appeals, the New York Court of Appeals. I don't know if an appointed lawyer would do it. I don't think a paid lawyer would do it, because I think it would be frivolous. There was pretty strong decisions, but this is family court, so you never know what people are going to do, especially, that's kind of the issue. Sometimes we have clients where they're paying us, but the other side isn't paying the lawyer. I think I talked about this with the child support case, a child custody case, a week or so ago, or a couple weeks ago, where I was a similar situation where the mom in that case has appointed counsel. She doesn't pay a penny. She doesn't care how long it drags on. Whereas my client is struggling to pay, and while the case gets dragged on. So we're really hoping that this is it. But if dad loses his job, he can always file for a downward modification. He can even if he doesn't, he could try. I mean, it's very hard a lot has to happen before the court will put it in an injunction and say you cannot file any more of these without court permission, which is another, issue that you run into sometimes with litigation. But my client's very happy. She's hoping that this can give her a conclusion on all of this, and we're hoping that too. So, these issues with child support can get very tricky, but they're very important. And it's important that you get the money that you need to support your kids. If you're the one getting the money, if you're the one giving the money, it's very important that you support your kids, and that the amounts are correct, and that before you agree to anything, if you're going to sign a stipulation, this wasn't a stipulation, I'm working on another case right now, before you sign a stipulation, make sure you're going to be able to pay the amount. Otherwise, we just use a percentage of your income to determine child support. But if you go above that, don't go above it. If you're going to end up putting yourself in violation in the future, you're just doing yourself more harm than good. That was a lot of a case to talk about, but that is all today for Notable Approvals. Don't forget to like us, follow us on Facebook, Twitter, and Instagram, YouTube, and catch us tomorrow for another Notable Approval. Thank you all for watching, and have a great day.